thank Mr. Pettis for standing up today and representing what they are doing to secure the votes, because that's been the concern from day one. That's more information than we've ever had. So we appreciate that, but we don't think it goes far enough. I want to start with the words from Judge Byron White in one of his last opinions on the Supreme Court. No right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. But the right to vote is the right to participate in an electoral process that is necessarily structured to maintain the integrity of the democratic system. That's Burdick v. Takashi, 504 U.S. 428, 1992. The right to vote necessarily must be structured in an electoral process to maintain the integrity of the election process. That is what this complaint is about. That is what our motion is about. That is what our complaint in Palm Beach was about in this subsequent motion. And I'm happy to report today, Your Honor, that I can represent to this court that the Palm Beach County Supervisor of Election and Rick Scott for Florida have agreed to an injunction in Palm Beach to the relief that we sought, the same relief that we're seeking in this case, because both parties in that case understood that the relief that we are seeking isn't to intimidate counters, isn't to stop counting votes, but it's to protect the integrity of the election. So very shortly, Your Honor, we're going to submit an agreed order in Palm Beach for these very exact relief that's requested in this case. This is not about voter suppression. This is not about stopping the vote. This is not about, as Senator Nelson's campaign said, intimidation. This is about protecting the vote when it's not as part of the recount. So, Your Honor, going to the merits of the motion, we have asked for a mandatory injunction, which requires 4 elements. We need to show irreparable injury, an inadequate remedy of law, substantial likelihood of success on the merits, and that it serves the public purpose. I'm going to take the last one first because I think that we can all agree that protecting the election integrity serves a public purpose. Whether you agree or not with the idea of sequestering ballots and voting machines with the Broward County Sheriff's Office when they're not in use, I think we can all agree, and it should be uncontested, that the integrity of the ballot and the integrity of the vote serve the public purpose. So I do not believe that such request would ever violate the idea of a public purpose. In fact, I think violating the election trust, I think violating the trust and confidence in the outcome of the election is a public wrong. And a public wrong is absolutely recognizable and preventable by an injunction. Now, Your Honor, irreparable harm. I want to harken back to Justice White's words. The integrity of the election system is at stake here. There are allegations and evidence submitted in our verified complaint and motion to this court that the Supervisor of Election of Broward County has engaged, not just in this election, but in prior elections of election issues, irregularities, and in fact, illegal conduct. Now, Mr. Pettis filed a response last night and we reviewed it. One of the comments that he makes is that these are unsubstantiated allegations. So these allegations are unsubstantiated. There's no evidence to them. Well, this very court in 2017 ruled in favor of a plaintiff against Dr. Snipes on summary judgment, looking at evidence, finding that Dr. Snipes committed a public records violation. She broke the law when it came to counting ballots. She broke the law when it came to keeping ballots. That was the Cordova matter in 2017, Your Honor. There has been, in the last year, a case that found that Dr. Snipes violated the law when it came to keeping ballots. And we don't have to go back a year, Your Honor. We can go back 4 days ago. And while that might seem like a year during this high-speed recount issue, 4 days ago, Judge Phillips, in this very court, said that Dr. Snipes violated the law. That's the world we're living in. Disagree or agree with what she is doing, but there is no dispute, and there can be no dispute, Your Honor, that Dr. Snipes has had orders entered against her during this election and in prior elections that she violated the law. What we are asking the court to do today is to remove any doubt. Take away the concerns of the citizens, take away the concerns of the public, that this election process will be protected. All you have to do, Your Honor, to take away that doubt, to fix the erosion of trust in this process, is to grant this injunction and allow Broward County sheriffs to monitor the votes when they're not in use. We are not asking the court to have Broward County Sheriff's Office overseeing or standing over the shoulder of people who are counting votes. We're not asking the Broward County Sheriff's Office to interfere with any count whatsoever. We are asking the court, when these ballots and these voting machines are not in use, to have someone other than Dr. Snipes, other than someone that listens and reports to Dr. Snipes, be a part of the inspection process.
Well, you heard, and I'm not sure you knew any of this, in fairness, what Mr. Pettis said. So I'd like to know the mechanics of what exactly it is you would have me do. I mean, he indicated there is an armed Broward Sheriff's Office representative at the door where the ballots are at all times. Beyond that, what else would you think it necessary to do to protect the ballots or the machines?
And the request that we're thinking, the mechanics that we believe, aren't too different than what Mr. Pettis said, which we talked about on the call, the conferral yesterday. Our issue right now is those sheriffs, those officers, report to Dr. Pettis. Or, no, sorry, Dr. Snipes.
Well, I don't think Broward Sheriff's officers report to Dr.
Well,
Snipes.
operationally, the operational control is, I believe, established by Dr. Snipes. If I'm wrong, you can correct me, Mr. Pettis. But the operational control of where these ballots are, what doors, that's established by the supervisor of elections office.
Okay, can I go back and focus on two things?
Yes, sir.
I understand the issue about the ballots, and now you've heard the ballots are in two places, segregated ballots that aren't being recounted and ballots that are being recounted.
Yes, sir.
Let me go back to the request about the machines. And I'm sure they're going to enlighten me on the other side there, but the machines are largely warehoused in a huge warehouse over there where the supervisor is, and they've been there, I assume, since election night. They transported from the polls and then back for storage. Is there something that you're asking me to do with respect to the machines themselves, number one, and number two, as I understand it, and someone will enlighten me, isn't there in each machine after the votes are completed during an election something like a USB drive or some type electronic data collection device that tallies the votes on that machine, and then that device is pulled out and given to the supervisor to upload to get the results? So tell me if I'm off on the mechanics, and if so, what your relief on those two items are.
On the first item regarding the supervision of ballots that are being counted as part of the recount and segregated, this is why I think there's been some confusion about relief. We want nothing to do with the recount votes. We're not interfering with Dr. Snipes' ballots regarding the recount. This is about the ballots that are not being in use. We do not want to slow
The
down.
other 5 pages of the ballots that they're not recounting, you want those secured somewhere?
Not just those 5 pages, but when they're done with the page as part of the recount and they move it back to the warehouse, that's when we want to have someone be responsible to supervise those ballots.
Okay.
As to the second point, I believe it is the case that there is a USB drive that is taken from the machine that dumps the data from each machine. While the recount is pending, until the litigation is over, we want someone to be supervising those machines.
Not the machine, but the USB.
But we believe the USB is within the
It's in the machine?
no, it's not in the machine anymore. I think it's
Okay, they're taken out of the machine and then they're uploaded into the voting mechanism to tally the votes.
Correct. We want the machine, but I believe the USBs are with the supervisor of election. I'm happy for Mr. Pettis to explain where those USBs are.
I will find out about that. Okay.
Maybe we should find out some of those information before we file the motions, Judge.
All right. Well, Mr. Pettis, you'll be heard on that in just a minute.
And Your Honor, I would like to address that point. On Friday, we came into court on a public records request because we've been asking this information. We've been concerned about this from day one, Your Honor. That is the purpose of this complaint. We haven't had access, we haven't had information, we haven't had transparency. And all three of those things, when you do not have, erode the trust in the election process. So I appreciate Mr. Pettis asking. We should have talked about that beforehand. We've been asking those questions, Your Honor. This is why we are in court today. Because one thing that Dr. Snipes has shown, after we go to court and get an order, we got access. We got some information. So that's why we're here today.
All right, I get that. Okay, so you want assurances related to the machines, the USB drives, both ballot sequences, the ballots that are being recounted and the ballots that are not being recounted. What other things are you concerned about as far as securing these items through the vote counts?
Your Honor, we believe that as long as those 4 buckets of information are supervised by Broward County Sheriffs outside the operational control or organizational control of supervisor of election, I think that would be sufficient for the
I think what you meant to say is someone independent from the supervisor.
Yes, Your Honor.
All right, thank you, Mr. Betts.
Good morning, Your Honor. We're talking about a constitutional officer in Dr. Snipes. A constitutional officer that has been there for 15 years, has managed these machines, continue to carry out her duties as dictated by her constitutional obligations. There is a presumption in the state of Florida, cleared by law, that a constitutional officer is presumed to carry out their duties and responsibilities. What you're hearing from Mr. Zimmerman is to ask you, Judge, to step in at a time where we're in the middle of a recount, to step into the process, and despite what they say, they file a motion. I'm going to go through the motion that they put in the public record. They put the stuff in the motion, and then they come to court, and all we're innocently asking for is this simple little request. They're putting the damaged stuff out in the public domain, and then coming to court with trying to cloak themselves in some innocence. Judge, in the motion that we submitted, in the response that we submitted to you, we have shown and stated to you there's numerous laws that govern our electoral process in this state. And she's fulfilling each and every one of those and submitting the information to the Secretary of State, who is the chief election officer. And if that individual at any point in time has not received what he's entitled to receive, I guarantee you he would speak up. If he believed that the manner in which they have kept these machines behind lock and key and security officers to suggest that Broward Sheriff's Office somehow are going to be influenced by Dr. Snipes, I think it's just outrageous. This process that we're talking about is a process that not only has the independence of our largest law enforcement agency here in this county engaged, but another tier of security, G4S, which also happens to cover the courthouse security, and another security company out there as well. We have 2-3 levels of security of this facility, and nobody is able to move about in these areas without proper documentation. They have not presented anything to suggest that someone got into this area and somehow had access or manipulated anything. They're just saying we would be more comfortable if we could somehow get an order from this court to at least imply that intervention was necessary because we didn't trust Dr. Snipes. You want to talk about what undermines our electoral process? That type of behavior, that type of suggestion without any evidence. They're talking about 2016. You know the issue of 2016 when the individual inadvertently discarded some documents in advance of the I got it. I can't.
Balance. You said
the balance. The balance before the retention schedule. We know, because it's all over that particular record, that they were scanned in the machine. Every single ballot that was discarded was in the machine. Should they have kept those ballots? Absolutely, for another year. There was a mistake happened. She's acknowledged that, and we moved on from that issue. But they continue to bring that up to somehow suggest something nefarious about what's going on now. Judge, you have a system going on that the canvassing board, who has 2 of our state county judges sitting there around the clock, participating in front of all these lawyers. What has happened here, Judge, they haven't brought any of this information up with the canvassing board. They've circumvented the canvassing board and suggested to you they have an emergency. They've not suggested to the canvassing board one time that they're concerned that something's happening to the ballots or something's happening to the voting machines or the tallying machines. No, they filed an emergency motion with you despite the fact that they were in front of the canvassing board all day yesterday. Not once did that come up. You have two county judges sitting there, and I'm sure you, as you know your colleagues better than I do, if there is something that they hear that they think is undermining the integrity of this process, they will take action. The transparency that they're trying to do out there is beyond what would be expected. Every single step, they're coming out and telling these folks what they're doing, how they're trying to do it. They have 8 people inspecting in the room. They're allowing everything you can possibly do, Judge. And for them to file this motion to suggest that somehow you need to step in the middle of the recount and to somehow sequester, and as they call it, in their motions here, to somehow come into this case and take control of the voting machines and the ballots, I think is taking you in an area, Judge, that the court should not be in at this time. Why should you not be in it, Judge? Because what they're trying to suggest is a contest issue. If there is a contest dispute that they want to bring, that happens, Judge, by law at the end of the county, at the end of the election. You don't get in the middle now and raise contest issues and ask for injunctive relief in the middle of the counting process.
Well, I don't perceive anything they're asking for relief on to be interfering with what's going on, and I would never be inclined to involve myself or any other judge in that because the supervisor's under very intense deadlines to get these ballots recounted and get it to the Secretary of State on time so that some of these questions can be answered. Can I just go back into...
Good. Can I finish with all due respect, Judge? Can I finish one point? I understand what you just indicated, Judge, but if you look at the motion, what they are doing, and I've now seen it twice in the last two business days. In the motion they have here, Judge, they indicate they're indicating that in the middle of the night that ballots are being moved. They know that's not true. Judge, I personally stood out there on Saturday with a throng of reporters, brought out to the public's view 2 boxes that are multi-purpose boxes that are used for provisional ballots as well as supplies. There was some suspicion out here in Twitter world that somehow boxes were being moved in the nights, therefore ballots are being moved. Now that's been cleared up on Saturday. It's been articles all over the newspaper on that. It finds its way still here in this motion. They don't argue it, but it's a part of what the media gets to keep the undermining of the electoral process going on. If it's not relevant to why they're here, why do they keep putting that garbage in their motion? Their motion is not as clean. As to their motion, Judge, that they're now saying is limited just to the safekeeping of ballots. Those ballots are under safekeeping. Dr. Snipes has multi-level of security. As to the ballots that are in the process, the ones that are being brought out, that are yet to be brought out, early voting that we're in the process of now, and then the day of the election ballots, those ballots are really in the custody and control of the canvassing board. They are observing that process. They're making sure that process goes timely and well. If there's any dispute about those ballots, Judge, they're going to step up. As it relates to once they've come through this process and they go back to the room, they're behind lock and key with guards back there. They're checked back in on a log. They're behind lock and key with law enforcement. There is no reason with regard to the voting machines. Once the voting machines come back, the USB chip is taken out. I'm going to allow Ms. Joseph to explain that process so that the court will be educated on the fact that that too is secured in a well-documented method consistent with what they do hopefully across the state of Florida in how we secure that data information. So I'll let her address that point this time.
Your Honor, if I may real quick on a representation that was made in our motion. Mr. Pez said that we represented in our motion that ballots were being moved. And I have our motion, it's 4 paragraphs long. Can I ask Mr. Pettis to refer where?
I'll tell you exactly where it is. You filed multiple documents with the court, and the document that you filed, not only the motion, but memorandum in support of plaintiff's emergency motion for injunctive relief. You're at the bottom. Over several days immediately following the election, Dr. Snipes was unable or unwilling to accurately respond. And in fact, thousands of additional documents initially unaccounted for, frequently in the dark of night. That's the language that I'm referring to, of their motion of memorandum of law in support of this motion.
Okay. Let me find out about the USB chips, sir, and I'll come back to you, Mr.
Thank you, sir.
Councilman.
All right, to continue with explaining how the data is kept. Each voting machine at every precinct preserves the data instantaneously after all the votes are entered. Once those votes are entered, the USB is placed in a secure media bag. That media bag is secured, then transported to the regional site where there is someone there, 2 security measures, a login book to make sure that all of that information is kept and transferred. Once that data is there, it's entered into the system. It's automatically uploaded. There's no room for error. It remains secure. Nobody touches it. In fact, all of the areas that maintain that data are maintained with high-level security, including access codes in addition to key cards. So even if you somehow got your hand on a key card, you still couldn't enter that mission-critical facility because you still need to have the code. As to some allegations about operational independence, the Broward Sheriff's Office is not under the operational control of Dr. Snipes. To the extent that she requests that they send some officers, they remain in control of their own officers. So that belies the intent. As far as the cognitive and literal dissonance about all of these allegations of, I'm not even going to get into all of the allegations that they've made because they're not worth repeating. But the point is, right now, we're at a point where we need to be focusing on the recount. And
can I ask on these USB tabulations, after they're taken to the regional site and uploaded, I guess, into the supervisor's computer system to tabulate the votes, where do those go? Are they still at regional sites, or are
they remain in? No, they go to the main security site where they have it with IT.
So they're downtown or down where the supervisor's office is. Correct. In that facility.
Correct.
And I thought I saw 477 or 577?
577 precincts.
577 precincts. Does that mean there's 577 USB drives?
There are.
And are the absentees or the mail-ins, are those votes also on USB drives to be tabulated?
Say that one more time.
The absentees and the mail-ins, are those on separate USB drives when they're tabulated? Do you know how that works?
I don't know about the vote-by-mail ballots. All of the other ones that are actually kept electronically or entered electronically are stored on USB drives. The vote-by-mail ballots, some of them we're still getting in because of overseas and military ballots. So those are not currently stored 100% on a USB drive, no.
Okay. All of these media bags that contain all of these USB drives, are they in the facility where the machines are at the supervisor's site?
They are on site at the supervisor of elections office, yes.
Are they in any kind of a safe, or are they just in an area that's secured?
They are in a secured area. I have to confirm whether they're in a secured lockbox in addition to that secured area. I'm not sure right now, but we can find that information out.
Okay. A few days ago when these things started to unfold, I asked the canvassing board to take a scanner out there because of everything that was going on, and I know the supervisor complied and put a scanner in place for people coming in and out of the facility. Was there a BSO officer there monitoring any of this prior to the release of the election results on Tuesday night, or do you know?
I don't know.
There was a BSO deputy.
Okay, but I'm assuming, if I'm wrong, tell me, that the BSO people were assigned there by the sheriff's department to basically keep the peace, to monitor, make sure nobody did anything unusual.
No, Your Honor. As a precautionary and security measure, the supervisor of elections contracts with BSO, in addition to Lauderhill Police, in addition to collaborating with the Department of Homeland Security to make sure proactively that everything is secure. It was not in response to
Oh, okay, that's fine. That's what I want to find out. Now, the law enforcement folks who have been on site since election night, is it there? Do they have something written or protocol to say that they are to monitor, for instance, the transport of ballots or the movement of any of these USB drives? Are they specifically there assigned to do something to ensure the integrity of the electoral process, or are they there for that process and other responsibilities? I'm trying to find out exactly what their task for the sheriff's office is, if you know.
If I may, Your Honor, Larry Davis. BSO I represent here. I'm here on Nikki Freed's part, but I can let the court know what's going on with BSO since I worked with them on voter protection. They have an entire team set up that monitors the pickups and also from the collection centers. And they've been at the sheriff's office the entire time. Captain
At the
Scott
sheriff's
Russell,
office, you said? You said at the sheriff's office, you meant the elections office?
Correct, yeah, the elections office, yeah. So
Okay, at the elections office is what I'm trying to inquire. What specific responsibilities do they have, if you know, regarding protecting the integrity of the balloting and collection of data process, or are they just there to observe?
they're there for security issues, Your Honor, and that's what their organization is set up for. There were a number of meetings with BSO and the people that are involved with the election. They do that every election cycle. And if the court would want to hear from I would suggest maybe someone like Captain Scott Russell, who was the command person over all the security issues.
Thank you, Mr. Davis. Hey, Pickford.
I would just add that specifically, I observed personally the BSO officers there last night. Wherever observers are allowed to participate from either party, they're there. They follow them. They're assigned to those observers to make sure that there's no interference in the process as far as an outside person.
The area where the machines and the media USB drives are, if you know, how many entrances or exits to that area are there?
I don't have the exact number with me right now, but I can find out. But I do know they're all secured and manned by a physical person.
So there's either a G4S or a BSO at all the doors?
Yes.
All right, thank you. Thank you very much. Anything further, sir?
Yes, very briefly, Your Honor. A couple of points that they made. First, they said they have no operational control. They testified that they contract with. The supervisor of election has contracted with the Broward County Sheriff's Office. There is some sort of agreement between the parties. And Councilman Nikki Freed responds, they're there for security purposes. They're not there for preservation of election integrity. They don't know specifically what they're looking for. They're not physically in the room.
All right, even if I were to agree with some of the, and I'm just going to put it the way I would put it rather than the way you want to put it in these papers, the suspicions that you all are advancing in some of your papers. If it's not the BSO, who is it that you would have me to put out at the elections office to make sure there's transparency and everything is protected?
We're fine with the BSO as long as they have directions over and above what they're contracted with the supervisor of election. Court-ordered directions and procedures regarding protecting the integrity.
Such as what, reporting to me?
No, just making a schedule, figuring out who they were, figuring out, making sure that people are actually looking at the machines, looking at the USB, figuring out what their actual procedures are. What does this contract say? I'm sure they'll be glad to produce it. We can probably make a public records request. What is the actual procedure? Because, Your Honor, Mr. Pettis had a righteous indignation about what we're asking and how we're doing it. And I do want to say none of what he said was in our motion and none of what he said is actually in our memorandum. What they take is our words and they ascribe a nefarious purpose. If you want to talk about nefarious purpose and they say we haven't addressed and it's cognitive dissonance, General Election 2008, a Broward judge found that Dr. Snipes violated the Florida Constitution. She's admitted to commingling provisional ballots with invalid provisional ballots, resulting in the initial counting of at least 22 invalid ballots. Not legal ballots, invalid ballots that Dr. Snipes said herself were invalid. In the primary election in 2008, she incorrectly stated the outstanding number of mail-in ballots. A judge issued an injunction forbidding Snipes from opening vote-by-mail ballots. In the general election in 2016, she sent out wrong vote-by-mail ballots. This is not supposition, Your Honor. This is not cognitive dissonance. There is one party in this case today that has been found in violation of election law and public access laws regarding transparency regarding this election, and it is not the plaintiff. Your Honor, we believe that there needs to be some procedure, some protection of the vote so that the integrity of the vote is met, and we're happy to work with the defendant to ensure that that process does not interfere with the recount and that that process can be sustained in a way that is reasonable under the circumstances.
Judge, if I may respond, I want to approach the court. Here is the memorandum of law. For counsel to suggest that I just read that wrong and that they did not put what I read in that paper is outrageous. At the bottom of that page, they say exactly what I said. And for him to suggest he didn't say it, Judge, that's exactly.
Your Honor, let's read what it's. During that same period, Dr. Snipes released thousands of additional, initially unaccounted for votes, frequently in the dead of night, with no explanation regarding her failure to account for them.
Exactly
That's not what he said. He talked about bussing in ballots.
Mr. Chairman, stop.
Judge.
Gene, have a seat. That's enough. Lenny, did you want to say something?
I would. Thank you, Your Honor. I appreciate it. First of all, I represent the Florida Democratic Party, and I do agree with certain things that Governor Scott has said in terms of the importance of the integrity of the election, making sure everything is done properly. We're fully on board with that. Here's the problem. The problem is, what is the perception going to be to the public if an injunction is entered in pounding machines or something to that effect? There will be, the public out there will think that something has gone untoward in this 2018 election. So let's look what the record is, because, Your Honor, you're going to need to make findings of fact if an injunction is issued. So let's look at what you could possibly put in the record as to what has transpired in 2018 in conjunction with ballots and counting. Nothing. All you have is a verified complaint verified by an attorney.
Okay, well, let me ask you, Mr. Simmons, from the Democratic Party standpoint.
Yes.
The way I view all of these things right now, at this early stage in all this, is there is so much rampant suspicion, charges back and forth from both sides about what's going on over there at the elections office. If I didn't enter an injunction, what would be a less intrusive method of giving assurances to the Democratic Party, to the Republican Party, and to the citizens of Broward and whoever else is interested in this recount? What would you have me do beyond just saying, well, Judge, we're doing what we're supposed to do, and we've got it all under control?
Your Honor, so in terms of addressing suspicions, the Democratic Party doesn't believe that suspicions are what should be addressed here. We believe what should be addressed here is what's the evidence in front of the court. If we were aware of evidence of fraudulent activities taking place, of corruption taking place, of wrongdoing being taking place, that has impacted the ballots or the vote count, we certainly would join with them in their motion. Our concern is the record you have before you, based upon a verified complaint signed by the lawyer, is about as weak as an injunction motion based upon the evidence that I have ever seen. So
far, all I've heard a bunch of lawyers arguing. I haven't heard any evidence.
That's my point, Your Honor. They must
stand up here and raise their right hand yet that I can see.
Well, they have to bring evidence, Your Honor, in order for this court to bring an injunction. You can't bring an injunction out of thin air. And there's two other points I'd like to make out of that. One is this is a mandatory injunction, which has even a higher standard than an ordinary injunction. Two is there is one issue that hasn't been addressed, and that is the substantial likelihood the party will succeed on the merits. There's no substantial likelihood of success that they will succeed on the merits, because you've heard from Mr. Pettis and Representative what is happening at the office right there, right now. So we're sorry about the suspicions that are out there. We've tracked down these suspicions, too, because we want a fair election. We want to make sure every vote is counted. If we thought that what they were saying was truthful in connection with the 2018 election, we haven't seen anything yet, we would be joining in their motion. So if there is evidence before your court, we would say, yes, there should be an injunction. There's no evidence before the court. There is nothing but suspicion. So the concern is, from the Florida Democratic Party point of view, is if an injunction is entered, against Dr. Snipes, when she hasn't done anything wrong in conjunction with the 2018 election. It's going to send the wrong message out that there has been wrongdoing taking place in the 2018 election, and perhaps the public will view things, poorly in terms of what is happening in connection with the 2018 election. So that's our concern, Your Honor. There's nothing here to...
Thank you, Mr. Evans. Mr. Houston.
Thank you, Your Honor. I have a different answer.
And who do you represent, Mr. Houston?
Nelson for Senate.
Thank you.
In order to do what the court wants, which we can't really do without taking evidence, an injunction can't be entered without evidence, and would probably take longer than today to do. But in order to do what all the parties in the court wants, which is to maintain the confidence of the public in the electoral process without creating new suspicions or somehow judicially validating some suspicions that there's no evidence for, I would suggest that you give the parties a few hours to file a joint motion that if all we want is BSO there, and BSO is already there, that we can all agree to. It can be a joint motion on including the supervisor. So when the court grants it, you're not validating any suspicions, and we're all agreeing on the relief that was suggested right now in court. Not the relief in the complaint, not the relief in the motion, but having private sheriff's deputies there. I don't think anyone would object to that. So my suggestion is give the parties a chance to file a joint motion doing what we all say we want.
Thank you, Mr. Houston. Sir.
Your Honor, briefly, I appreciate the comments. I'm always happy to chat. We had a good conversation with Mr. Pettis yesterday. We're happy to talk about this later. But I do want to clear up a couple of quick points. One, there is evidence in front of the court. We filed a verified complaint. The verified complaint can be considered as evidence. Number two, there is problems with the 2018 election in regards to Dr. Snipes' conduct. There has been a court in the last 96 hours that found her to violate the law in relation to the 2018 general election. So you cannot say and stand up here and say there's been no allegations, there's no issue regarding 2018 general election. That's simply not the case. And I want to end with this, Your Honor, and I, once again, will take up my multiple opposing counsel offers to confer and figure out a way to protect the integrity of the vote. But past is prologue, Your Honor. Those are famous words from William Shakespeare, and I believe that to be the case. We have a trust issue in this county. We have a trust issue in this process, and we need to do something now before it is too late so that we can have trust in the outcome of the election.
Thank you, Mr. Mitch.
Just real quick, because there's case law from the 4th District right on point. Verified motions or complaints are not sufficient. At the very least, Mr. Zimmerman would have to take the stand and be cross-examined.
Thank you. Excuse me.
I think he's talking about the Orkin extermination case, which is what I was getting ready to say. If he wants to stand on his verified complaint, let's get him on the stand, and we can cross-examine him. With regard to, he said it several times, Judge, with regard to she's violated the law in 2018 with the order of Friday. Just so the record is clear, and I'm sure you're familiar, Judge, there was less than a 24-hour period to respond to a public records request. I stood before Judge Carolisa Phillips, and I said she's not denied access to public records. She's intending to give it. She had been before the canvassing board for 10 hours in that period of time. 10 hours of one day, within 24 hours. I said, I will speak to her. She has no intentions of not providing the information. She created a deadline of 7 o'clock p.m. on Friday. By 5-something, the information was in hand. We supplemented that information, Judge, later that night about 8:30. I then was on the telephone with Mrs. Zimmerman because they didn't understand what they had gotten and agreed to meet them out at the site to let them see the computer portals that we got the information from. I met them out there for almost 2 hours. It was an hour and a half time, Judge, to educate them on what the data was, way beyond any public records request. Within 48 hours, we had done all of that. And that's what he keeps referring to as far as you've been found in 2018. We have a motion before Judge Phillips. There was no evidence gathered at that hearing. It was, again, Mr. Zimmerman's words that she entered the order, and we'll follow that up at the appropriate time with the judge. That is, we believe, a totally improper finding without any evidentiary opportunity for Dr. Snipes to address. Judge, with regard to the matter at hand, when you asked Mr. Zimmerman, what would you like? Early on, he mentioned Broward Sheriff's Office. When I talked to him in the parking lot yesterday, our last conversation, he mentioned to me, Gene, if we can get some independent party like Broward Sheriff's Office to be there to observe. That's all we want, because we believe that will quiet these people out there. And I told him I don't think there's anything that's going to quiet those people outside. I don't think this is going to quiet those folks that are screaming outside. You now come in, Judge, and we have fully disclosed, and I've been up to the late at night, as has Ms. Joseph, bringing forth to the court all the safeguards we have in place. That includes Broward Sheriff's Office, that includes a second tier, that includes secure areas, that includes key code access, that includes everything you could possibly imagine, Judge. They've now been educated. More importantly, Judge, this has never been taken to your canvassing board. And if there's something else that needs to be done, I do not think it's timely, Judge, for there to be some intervention. I think the process needs to be allowed to be played out, and you have a canvassing board with 2 judges on there to hear it and to take whatever measures they think in addition to those that are being taken, as opposed to having an order by the court, which carries a heavy implication, and they will use it, Judge, just as they're using Judge Carolisa Phillips to put in every single document to say, now we got a second judge that had to intervene. And this court is going to be in the middle. Once this count comes out, if Governor Scott doesn't win this race, what they're doing now is to utilize your order to say, see here, it was all undermined by the Democrats and Dr. Snipes. I ask the court not to be used that way.
I've heard what you're saying. Thank you. I'm nowhere near where the parties are asking me to be with respect to this limited hearing that I'm conducting on a holiday. It is an abbreviated hearing. So here's what I'm going to suggest right now, without making any findings from either side. It is now 20 minutes till 12, and we have everybody involved in the case in the room. And if I don't keep you all together and you all go off on your email exchanges, things can sometimes go downhill. My suggestion is, number one, I don't think I have any evidence to enter a mandatory injunction right now, and the law that I read on mandatory injunctions is disfavorable. But with that said, because there is so much going on in the public domain, I believe that there needs to be some additional layer of confidence that the votes are being protected, the machines are being protected, etc., over the elections office. I'm not casting any dispersions on either party or any elected official right now, because I don't have any evidence other than what the lawyers have put in their verified complaint. What I would suggest, and I'm going to leave it to you all in this way and then maybe reconvene in a little while and see if you all can reach an agreement. My suggestion would be to place 3 additional Broward Sheriff's officers at the elections office who report to a supervisor that's unrelated to, what did you say, Russell? Is that his name, Mr. Russell?
Who's the captain?
Okay, unrelated to Captain Russell. Another person of supervisory there at the sheriff's office, maybe from some other substation that's not over the elections office, either a combination of 3 Broward Sheriff's officers or someone from the Lauderhill Police Department. One, maybe monitoring the cameras to these rooms. One stationed directly in the rooms where these machines and USB drives are located. And one additional deputy there to supervise, if the sheriff could put a supervisor over there like a sergeant. Those 3 deputies would be independent from the supervisor's office and would just basically be doing what both sides, I think, are wanting here, is to make sure that everybody has a degree of comfort that no ballots are leaving the office, that they're all protected, and the integrity of the process is assured. So I'm not ordering that. I'm not making any findings. I think what we need to do is this. It's now, as I said, 20 to 12. I'm wondering how you feel if we reconvene at 1 o'clock so that you all can talk about this. Mr. Pettis, I don't know what your schedule is.
Yes.
But we could reconvene in an hour after you all had a chance to talk, or you could go back and visit in one of the jury rooms, and I'll be on call to come back, or however you want to handle as far as scheduling. But before we leave that topic and what your discussions may be on that, I still want to discuss when I have you all here the potential issue of consolidation. So I'm not going to do it right now, but you can talk about that in your meetings as well. So first, Mr. Pettis, what would you say with respect to that schedule or that issue?
I think an hour would be sufficient, Counsel. Does everybody agree?
Yep.
That would be sufficient, and just so when I go in the room, I have an understanding, Judge. The number of deputies there now, which Dr. Snipes called for to be there, are we to use those, or we want?
I want 3 deputies that are reporting to a supervisor, hopefully one of them a supervisor, independent from that collection of deputies that Mr. Russell uses, because you already have that layer of protection. So it'll be a second layer of protection that they would report to someone else who's not assigned to the elections area, and the sheriff could make that designation himself.
Okay.
And that way, you have 3 more armed, law enforcement, neutral people observing what's going on over there, and some of these things will hopefully calm down.
Okay.
Now, before I leave, I just want to say one last thing on all of this. Both sides, and I'm talking about lawyers, not politicians here, because I have jurisdiction over lawyers, not politicians. I am urging, because of the highly public nature of this case, to ramp down the rhetoric. If someone in this lawsuit or someone in this county has evidence of voter fraud or irregularities at the supervisor's office, they should report it to their local law enforcement officer. If the lawyers are aware, they should get the person to swear out an affidavit. But everything the lawyers are saying out there in front of the elections office is being beamed all over the country. We need to be careful what we say. These words mean things these days, as everybody in the room knows. So I'm urging everybody to wait till these counts are over, and there's going to be plenty of time to litigate whatever anybody wants to litigate. But let's let the voting process conclude. Let the supervisor do what she's directed to do by the secretary so that it occurs on time, and hopefully get another layer of assurances over there. I also want to urge you, Mr. Pettis, because I think since you've intervened in this case, things have rapidly gone in the right direction because the levels of communication have increased significantly. I would hope that you could emphasize to the supervisor that more transparency in this case is better. If they can give updates every couple of hours, or give the canvassing board the right to give updates every couple of hours over there, so that everybody knows how we're proceeding with the counts, how many have been counted, like the county attorney told us a minute ago. It seems to me that transparency is imperative in this case, and I hope you all will find some way to keep doing that.
And on that point, Judge, just I agree with you 100%, and I'm happy to say that in a conversation yesterday for about an hour with Dr. Snipes, she agrees with you. We've talked about doing some type of every few hours video clips, really short, just to keep people informed of what's going on. It was a part of what we did yesterday of educating the public on how long each phase is going to take. We're going to continue to do that. I accept your suggestion, and I think it'll go a long way in hopefully quieting down a lot of this hysteria.
All right, thank you, Mr. President. Mr. anything further?
No, Your Honor, just for real quick for our 1 hour time period, I believe there was another matter that's consolidated, so new. I don't want to, someone has to be here for that one. I don't want to.
Okay, here's what we'll do for you guys, if it's acceptable. I'll get the deputies to open the courtroom in the very corner over here on this floor, so you can have a private conversation yourselves among yourselves. If you need to use that, you can go out to lunch, whatever you want to do in that corner. Someone in this group has my cell phone number. I don't know who does, but someone can get a hold of me by phone once you all have decided you need to reconvene, and I'll come back to the courtroom. I'm sorry, Mr. Lemieux, what did you have?
I have an independent motion, Your Honor, which we could hear now or we could hear after the break.
It relates to?
It relates to Matt Caldwell's case, and it's our request for enforcement of public records request.
All right, what I'll ask you to do then, George, is join the other meeting, speak to Mr. Pettis, see where the issue lies. Once you have a further discussion, based on what I've done today, we'll take it back up at the next hearing when we reconvene after you all have your discussions.
Yes, Your Honor. Thank you.
Okay, so right now it's 11:45. We'll say more or less 12:45.
Thank you very much, Your Honor.
Thank you all. We're in recess.